Hi, you're listening to Listed by Mina Kuper. We're about trust, probate, divorce, real estate, and more. And we're listening to 98.1 FM, 1220 AM. You can also listen and watch us on KHTS Hometown Station page on Facebook. And if you don't have the Facebook page, you can go to the App Store and download the KHTS radio app and listen to us there. I'm really excited. I have amazing people on my show, and today I have an extraordinary person, an attorney. His name is Afshin Asher, and he is an estate planning, trust, and probate attorney. And he's just phenomenal, and what a nice person. Truly has a heart of gold, but very smart, very real. He knows what he's got to do. Afshin, I just want to say thank you so much for being on the show with me today.
Oh, hello, Mina. Thank you for having me. I'm honored.
Yes, no, I loved talking to you, and I found you to be very knowledgeable. You know, some people put their heart and soul into things, and you do. It's not just a job for you, and that's what is so appealing to me. That's the kind of people I like to work with. So, and I get these questions because, I'm a certified trust and probate realtor, and people ask me, and I'm like, there's so many things that go into this. You really need, an attorney that specializes in this, right? And the big question is, right, what's the difference between a will and a trust? Should they have both? Because people, unfortunately, think a POA or just a will is good enough, especially not because they own property. Do you want to go into detail about that? Because this is such a common question. It doesn't matter the education level or the age group. Everyone asks the same thing.
Of course, I'd be happy to. Being a lawyer, first things first, I have to say that I am licensed in California and my expertise is in California. So some of the information I'm about to provide may only be correct in California, honestly. So we, of course, always advise everyone to confer with local counsel because the rules change from state to state. But generally speaking, to answer your question about what's the difference between a will and a trust, well, a will is a standalone document. It's an expression of a person's wishes as to what happens with their assets and sometimes their minor children if something happens to them. And that's fine if you express your wishes, but then somebody has to be able to carry out those wishes. And that person is called an executor. But the issue with a will is that your assets remain in your name. And so if something happens to you, the executor cannot just simply sign on your behalf and say that I'm transferring the house to the person's child or spouse or whoever else may be the beneficiary. The executor can't just sign. So what they have to do is to go to court and ask for a probate judge to do that. And the process whereby assets of a decedent pass according to the terms of the will is called probate. And at least in California, this process is a long and fairly painful process. These days, it seems to be taking me about a year and a half, and it's pretty expensive. Now, in contrast, a trust, of course, is also a document that expresses a person's wishes, but it doesn't stop there. You have to take an additional step of retitling assets out of that individual's name to the name of the trust. So, for example, my house was retitled from my name to the name of my trust. It didn't really change anything. It's still my house. I still control it like I did before, but it's titled under the name of the trust. And the thing about a trust is that it continues on even when I'm no longer around. So if I'm not around, but the entity of the trust still exists, and the trust owns the house, for example, and the next person in line to administer my trust, we call that person a trustee, would simply take over and distribute the assets. And so we're able to completely avoid probate proceedings when we have a trust and your assets are in the trust. Now, in contrast, I'd like to point out that no matter how well written a trust is, how comprehensive it is, if you have a trust but don't transfer your assets into the trust, then it defeats the purpose. It doesn't accomplish anything. Your assets still go through probate. So that is why I often recommend that even if you have a trust, as a safety net, as a backup, you should still have a will just to make sure that if something slipped through the cracks by mistake, we're able to, at the end of the day, make sure that it goes to your heirs according to your wishes.
Afshin,
So that was
wonderful.
a long answer to a short question.
No, but you know something? Well, what I like about the way you explained it, you went into detail. And, you know, people go into blocks of what it is. But when you tell the story, they can wrap their head around it. And, of course, they can go back to the app or the Facebook page to listen to it again. So I think that going to detail the way you did is much easier for a person who's not an attorney to understand what it is that this all means. You know, so I thank you for that. And I know, it's wonderful. So there are taxes, right? Estate taxes, right? Welcome to California. What is the threshold for estate taxes, also known as death taxes? What does my net worth have to be in order to have an estate plan?
That's a good question. So, ironically, even though we're a pretty high tax state in California, California does not have any estate taxes. Some states do, but California, fortunately, at least for now,
that's great.
Does not have any. So, yeah, first time. You don't often hear that about California.
No,
but,
not at all. Everybody's going to move to California now.
And most other states don't, but there are some other states. For example, I know Washington State has a estate tax, but essentially, an estate tax is a federal tax, and it's in conjunction with a different tax called the gift tax, and both of those together are transfer taxes, meaning a tax on transfer of assets from one person to another person where it wasn't a sale. So if you were to transfer your house, for example, to your child while you're alive, that transfer is a gift and therefore subject to a gift tax. And if it occurs after your death as an inheritance, then that is subject to estate taxes. And both of those have the same exemption. Currently, it's at an all-time high of $12 million. So you can transfer during your lifetime or at death up to $12 million and not be taxed.
That's amazing.
Anything more than that is taxed at 40%. So, and the two are related. So if you gift or transfer while you're alive $6 million, then that means that at death you have another $6 million that you can give away. It doesn't.
So everybody should just give me the extra million. If it's $13 million, I can take the million.
Right.
And don't worry.
There's a few people that are exempt. So spouses, especially U.S. citizen spouses, are exempt. So even no matter how much you leave to your spouse, it is not subject to the tax, gift tax or estate tax, as if they're U.S. citizens. And also, if you make gifts or transfers to charities, those are not subject to the tax as well.
Interesting. So you often hear people die and they leave it to a charity. So the charity is not subject to that.
Exactly.
Wow.
So
okay.
So and then interestingly, I get a lot of clients then come and tell me, well, my estate's well below $12 million, so I don't really have to worry about estate planning, do I? And so this is where the concept of probate and the concept of estate taxes get confused. And whether or not you're subject to estate taxes has nothing to do with whether your assets would go through probate. So you could have an estate of $1 million, and that would go through probate for a year and a half. So
Yeah.
I don't think that people should think that because they don't have to worry about estate taxes, that doesn't mean that they don't have to worry about estate planning, because probate is an issue, and especially if you have minor children, there are a lot of other issues that come into play because the minor child cannot control assets until they're older in age as well.
Right, and
So,
if someone should become incapacitated for even a short period of time, that trust I would think, would play into who's going to take care of that minor child while you're not capable of doing so.
that's a wonderful point. That's absolutely true. So the entity of the trust exists while the person's incapacitated as well. And not only is that person's needs, provided, but also their dependents, including children. That's a great point. Absolutely.
So if there's a minor child as a beneficiary of a life insurance plan, will it go through probate? How do they handle that?
Well, so a lot of people say that, life insurance has beneficiary designation, so that doesn't go through probate, right? And the answer is yes, it doesn't. It doesn't go through probate. But the problem is that how does that child then get the money?
Right.
If you're under 18, you can't go and fill out a form and sign a form. So although in theory we have avoided probate, we haven't, because now you still have to go to probate court for a custodian to be appointed over the life insurance policy just so that you can collect the policy. And again, that takes a long time. And if you had simply named a trust, your revocable living trust, as a beneficiary of the life insurance, we wouldn't have to go through probate courts, although not per se probate proceedings, to have a custodian appointed over the accounts, because the trustee of the trust would be able to manage the insurance proceeds.
Right. And then, it's so important to think about this because, unfortunately, anything, God forbid, can happen at any time in your life, and people they'll put it off because they don't like the thought of it. But we all watch the news and hear the news about all these people that unforeseeably passed away at a young age, probably before they thought they would die. And that's why, especially when there's children, it's so important. You owe it to them to make sure they're taken care of properly, So I know there's revocable and irrevocable living trust. Does a revocable living trust protect assets from a lawsuit and creditors?
Okay. So this is, again, a situation where the laws may differ from state to state. But in California, for the most part, or almost always, any kind of trust does not protect the person who created the trust. So if I put my house into a revocable trust and I get sued, creditors can reach it. If I put my house into an irrevocable trust where I'm the beneficiary, it's still my house, I'm the beneficiary of the trust, it's still not protected, because by California law, we have what is called the self-settled trust rule, which says that if you create a trust for yourself, it's not protected. It doesn't matter. And if you think about it as a matter of policy, if it was so easy that you could just create a trust,
everybody would do it,
not have to worry about creditors, that people will just do whatever they want to. So,
whatever they want, right?
Yeah. So societally, maybe it's not a great idea to make it that easy to protect yourself. There are other means of protecting yourself to some extent, but where you retain beneficial interest in a trust, revocable or irrevocable, it does not protect you in California. And unfortunately, that's a common misconception where I get people calling me wanting to set up a trust because they're worried about getting sued, and I have to be the bearer of bad news saying that that's a misconception.
They're looking for a way,
does not protect you. Yeah.
They're looking for an angle.
I wish it did. I wish it did, believe me. But
I know.
But,
unfortunately, sometimes people get sued for not really needing to be sued, and people just sue them because they can, and unfortunately it happens.
Yeah, especially car accident cases all the time. And
That's right.
But no, unfortunately it's not so easy.
So and I know people have said this to me too, and I said, you need to talk to a lawyer. should I transfer the house to the kids now while someone's still alive instead of setting up a trust?
Yeah, amazing how often I get that too. People call and say, what, if I don't have to write a will, I won't have to write a trust. I just give my house to my child now. So there are a number of reasons why I don't think that's a good idea. So the first reason has to do with unexpected consequences. You transfer your home into your child's name, and then your child gets involved in a lawsuit, or gets divorced, or something happens to that child, and all of a sudden your home is at risk. So I don't think it's a great idea to entrust your assets to someone else while you still need to use them.
Right, because it leaves you.
Second of all,
yeah.
Yes, exactly. Second of all, there's a very important tax opportunity that is lost out on when you transfer an asset during your lifetime. And I don't want to give your listeners a headache right now, but I'll try to say that precisely as I can. When you transfer a house to someone while you're alive, that person acquires your cost basis. So if I bought a house for $100,000 and I give it to my child, it's as if the child bought the house for $100,000. So later on, if they sell it for $1 million, that means they have $900,000 of gain. But there's a big loophole in the tax code that says if you keep your assets till you die, and then your heirs inherit it after you die, they will wipe away all of that gain and assume that the inheritor received the property at the same cost that it was worth when you died. So I may have bought a house for $100,000, but when I died, it was worth $1 million. It's as if my child purchased that house for $1 million. The entire $900,000 of capital gain is forgiven by the IRS.
That's amazing.
And so that's is essentially the biggest loophole in the tax code. And you just have to hold on to your assets and have your family inherited to take advantage of it. So it doesn't make sense to me to forego that. One quick other reason, and that is that in California now, if you transfer your home to your children while you're alive, that may trigger a reassessment.
Yeah. That's amazing. Afshin, this has been so amazing. And again, people can watch us and listen to this again. What's a good way for people to reach you directly?
Great. Our phone number is 310-788-0444. We're in Los Angeles, and we can be found on the web at www.lataxlawyer.com. That's singular. lataxlawyer.com.
Love it. Love it. Afshin, thank you so much. You are just pleasant to talk to, and I love talking to you because you really care and you really get into it. You really do, and I appreciate it.
Thank you so much. This was a pleasure.
Have a great rest of the day. Hi, you're listening to Listed by Mina Kuper. We're about real estate, trust, probate, divorce, and more. And I have an amazing professional on the phone. He's an attorney. He handles bankruptcy, and he's been doing this a long time. He is just a whiz at knowledge. He doesn't have to look things up. He knows the law. And as everyone knows, things are changing constantly, right? They're changing faster than we can remember what they were before. So I want to say hi to Markus, the bankruptcy attorney. And Mark, thanks for being on the show today.
Sure. Good afternoon, Mina. How are you?
I'm good. Wrapping up the week and looking forward to the holidays for some downtime, to be honest with you.
Yes.
I'm sure. I don't know. Do you have downtime, Mark?
As much as any other week, but yeah, holidays are always nice. So.
Good. You can't. They're like, oh my God, I got a letter, and they're like,
There's always emergencies.
Right. Exactly. That's what I figured. You're like a doctor. So, Mark, again, thank you for being on the show, and I want everyone to know the different chapters because I think this is the biggest question people have. and a little bit about what each one means, because everybody could watch us again on the Facebook page or reach out to you for more detail. So the 7, the 11, the 13, can you go over it briefly? Because I think this is such good information, because they're not quite sure what the threshold is, kind of, sort of,
Yeah. Well, it depends, first of all, if you're talking about filing for an individual or for a corporation. But for individuals, the basic chapters are Chapter 7, 11, and 13. And the basic difference is Chapter 7 is you don't do any payments. You're not making any payments on your debts, and you're just basically trying to discharge, meaning get rid of as much debt as you can based on what you're allowed to get rid of. You give up, in return for that, you give up any assets you have for which there are no exemptions. And each state has various exemptions you can take to protect your assets. For example, you have a homestead exemption in California of anywhere between, it's around 330 to 630,000 right now, depending on where you live. And that would protect that amount of equity in your home, and various other assets have exemptions that protect them. So if you're filing a Chapter 7 case, if you know what you're doing, you're not usually going to lose any of your assets, and you would get a discharge of your debts. The Chapter 11 and 13 basically are repayment plans, where you would pay a portion of whatever your disposable income is, whatever you can afford to pay per month to your creditors. And in those chapters, you do not lose any assets or property that you have, but you have to pay out at least as much as the non-exempt value of the properties are. So, for example, if you had more equity in your home than your homestead exemption covered, you'd have to pay out that additional amount over the term of your repayment plan, which is typically, in a Chapter 13 case, it's 36 to 60 months, depending on various factors.
So interesting. That's good to know. And I'm sure people will link back and take a look at what you said about that, because I think those are huge questions. And then if they want to go further, to reach out to you, because I tell people, you talk to people, and people have lives, especially in real estate, and people get personal and dealing, especially when someone passes away or has issues. Things happen in life, and it's okay. It's better to handle them and be proactive instead of reactive, because then you just dig a hole deeper. And, people that are wealthy file bankruptcies, I mean, it's just to reorganize. If something happened, they can't get ahead of themselves, and it's quite all right.
Well, people that are, not to interrupt, but I mean, the people that are...
No, go ahead.
Yeah, people, business-savvy people. I mean, I'm not just going to say wealthy people, but people who have business knowledge tend to be very proactive about taking advantage of bankruptcy, not because they are sneaky or sly, but because they know what the laws are, and they understand that it's basically a business decision. Whether you're an individual or a business, it's a business decision whether to file a bankruptcy. It's purely an economic decision, and it's something that most individuals have a real problem with, just emotionally, going through it. When it's easy for me to say that they shouldn't feel that way, but it's true. And more people with more money and more business savvy aren't as encumbered by that feeling, and they tend to run into less problems as a result of that, because they're able to be proactive.
And the other thing, let's get into business, which is corporation status, versus personal. when would someone handle potentially a business, and would they close down the business to do this or be wanting to close it down? Because I think that, especially with the pandemic, a lot of people fell behind. So this may be an opportunity for them to get help.
Well, closing down a business is something you're going to have to decide just based on the economics of the business. I mean, you have to determine, is there enough, sales or profitability to maintain the business going forward with whatever the expenses are, and that's just something you have to just figure out whether it makes any sense to go forward. The bankruptcy, if you're talking about a corporation, because an individual can have a business too. I mean, I'm self-employed. There's a lot of people who are self-employed. Those are businesses, but that would still fall under the personal bankruptcy category as far as the options that are available. But if you're talking about a corporation or an LLC or a partnership, those types of entities, the bankruptcy options, you either have to decide, are you staying in business or are you going out of business? So there's really only two choices. And if you're going out of business, there usually is no reason to file a bankruptcy case. Because you don't, the corporations don't get a discharge of debts in a bankruptcy if they're going out of business, and more importantly, there is no need for them to get a discharge of debts because it's just an entity that is, the only remedy that the creditors of the corporation have are whatever the assets of the corporation are. So if the corporation has a lot of assets, there might be a reason to file a Chapter 7 case for it and have a trustee liquidate the assets and pay the creditors, but the debt is still going to remain against the corporation, which is fine. I mean, you have to talk about whether or not there are personal guarantees of the owners. If the owners sign personal guarantees, then they may need to file a personal bankruptcy case. But as far as the businesses go, if they're going out of business, they probably don't need a bankruptcy. And if they want to stay in business, their option would be a Chapter 11 case, which is a business reorganization. That can get very complicated as far as how that works, and whether it's worth it or not in any particular case. But it is basically a payment plan, as I said before, which you propose, to repay the debts. But there's a lot of requirements for the different types of debts and things like that. So it's way beyond what I can do in a quick radio.
Right. You can't pull your magic wand out and just tell it in a short story.
And I do have to look things up. I don't have everything committed to memory.
Come on. You're not old, or you know this stuff. I know, but I know each situation is different, and rules apply. And there are some formulas that people use, especially when it comes to taxes, right? That some people can bankrupt some of the taxes they owe, but there's a very specific formula to that. So, but it's definitely worth looking into if you're, fell short of something that happened. Definitely worth calling Mark to look into this, because he definitely will give you the answer that is real, because I know people have called me before, because I've become a trusted advisor, right? and bankruptcy attorney, I spoke to this person, and I don't know, it didn't sound right, And then, of course, we're all human, so, when you want someone who knows what they're talking about, Markus is definitely the guy to go to. So if they want to stay in business, there's a bankruptcy option, right, of restructuring.
For a corporation you're talking about?
Mm-hmm. Yes. Yeah,
well, I mean, yes, they can do a Chapter 11 case to stay in business, but whether it's necessary or not really depends on the fact of the case. But because Chapter 11 is basically what it comes down to is a negotiation with the creditors to come to some sort of an agreement as to how much is going to be paid. It gets rather complicated because there's a lot of rules in Chapter 11 with regard to retaining the ownership of the corporation if you're paying less than 100% of your debts. And it can get pretty tricky, but there is there's a new subchapter of Chapter 11 called Subchapter V, which it was designed for smaller businesses, and I believe the threshold on that at the moment, and I do have to look things up, but I think it's having I think it's if you have less than $7.5 million of debt total, you can qualify. There are other criteria for that, but the Subchapter V makes it more like a Chapter 13 case where you basically just propose to pay whatever your disposable income is projected to be, and you do that for a period of time. And as long as you do that, and as long as the value of the assets don't exceed that amount, then you should be able to discharge your debts after, if there's any left over after making those payments. So there's different types of Chapter 11, and whether it makes sense in your situation really depends. You have to really take a look at all the facts, but it's very powerful. It'll stop any lawsuits, and it'll prevent creditors from taking collection action against you, and give you breathing room to reorganize, basically, to if you need to get out from underneath some burdensome debt and move forward. But you're going to have to be you have to be able to maintain the ongoing expenses of your business. You can't keep operating at a loss. It wouldn't make sense to continue a business that's doing that anyway. So.
And what's the longest someone can stay in a Chapter 11 before they discharge it and get you out of it?
Well, I mean that depends. That depends on the case. I mean, there is no specific time limit.
I see.
It's up to what you agree to with the court and the creditors. I mean, some cases. I mean, they go on for many years. The Subchapter V, which is more like a Chapter 13, is generally about It's generally a 5-year repayment plan. But the regular old-fashioned Chapter 11, there's no real specific time limit, but there's always this sort of feasibility question in a bankruptcy that you have to be able to show your ability to make the payments that you're proposing to make. So if you're trying to put together a 30-year plan, for example, how are you going to show that you're likely to be in business in 30 years, or even alive for that matter? So, so the longer it is, the more difficult it's going to be to get a plan approved. So in other words, you can't just have $10 million of debt and propose to pay $100 a month. I mean, it's not that's
right. It doesn't work that way
for 100 years or something like that. Yeah. So I mean, but there's different criteria that determine how you would propose an amount to be paid, and again, a lot of it depends on the negotiations with your creditors in a Chapter 11 case.
So the other question, because I'm sure this is a biggie, married couple, can one file bankruptcy without the other?
Absolutely. There's no requirement that they both file, but the information about both spouses, meaning their income, their debts, their assets, all go into the pot. So it's not. You're not really accomplishing anything by filing bankruptcy without your spouse. As far as you're not like reducing
community property, right?
You're not changing your eligibility. You're not protecting property that isn't already. If it's not already protected, you're not going to protect it by not filing. You're not joining in the filing if you're a spouse. Because California is a community property state, so it's all there anyway.
Well, what happens if the spouse has a trust and assets and money in a trust prior to marriage, and the other spouse is filing bankruptcy? Is that trust protected if it was prior to the marriage?
Well, I guess it depends on the type of trust and how it was set up. And I mean, then you're getting into nuances of community property law that I'm not really qualified to.
Right. Because I think that it's interesting because that's why people need to speak to a couple of attorneys on these different matters.
Right, because if the trust is the separate property of the other spouse, then it's going to be protected regardless of whether that spouse files the bankruptcy or not.
Right.
Because, well, actually, no, that doesn't make any sense what I just said.
Mark, hold that thought. We're going to be taking a commercial break. We'll be back in a minute. You can regroup. It's a lot of information, and we're coming up to the stretch of holiday time, so we'll be right back. Hi, you're listening to Listed by Mina Kuper. We're about real estate, trust, probate, divorce, and more. We talk about everything that can happen in these situations and how to make it all work out for you, or try to work it out. We're at 98.1 FM, 1220 AM, also KHTS Hometown Facebook page or the KHTS radio app if you don't have either one. And I want to return back with Markus, who's a bankruptcy attorney here in California. Mark, welcome back.
Thank you. I'm still here.
Good. Oh, good. Yay. That's a good thing. People are going to need your help. So we were talking about the bankruptcy of couples, right? Was that what we were up to?
Yeah, I had misspoken a bit when you asked about what would happen if one spouse had assets in a trust.
Yes.
I mean, if it is in fact, the issue is whether it's community property or not. So I mean, these assets in a trust, if they were put in a trust during the marriage, it would be community property. But if they were in the trust before they got married,
right.
Then it might be considered separate property, but it's also going to depend in part on whether the trust is revocable or not, and some other factors.
Right, there's all these things. Right.
Yeah, it gets pretty complicated, but yeah, I mean there are certainly instances where we have one spouse owned, for example, they owned their house before they got married, and and they've made all the mortgage payments on it. And then they get married, and then there's the question of whether it's still their separate property. So in California, it's their separate property unless they've done things to alter that presumption, and so it can get pretty complicated. Where because if you're married for many years, and you're making mortgage payments from community property, then there's going to be some portion of equity that increases in the property that is community property. So
when they say till death do you part, they ain't kidding, right?
Well, no, but if you're entering into a marriage and you want to keep property separate, then you need to. That's something you need to plan for. Right. You need to plan for that at the stage of when you get married or before you get married with a prenuptial agreement or whatever. It's pretty important because otherwise even things that were your separate property before you got married become community property after you get married, and so they're going to be subject to your creditors being, or either of your creditors, either the husband or the wife, or however, wife and wife, however it is.
Yeah.
Going after the assets. So,
right.
So.
Yeah, it's so many, and that's why, people ask friends that are not attorneys. I always say, I asked a friend, my friend told me. And I'm like, why are you asking a friend? They're not attorneys. They don't specialize in it. I'm like, I don't know, because I think they went through it. Don't ask your friends. Ask an attorney. Because they're not going to give you the right answers, potentially. There's so many different angles. There are laws, there are codes. They're not going to know the codes, right? I love it. I asked my friend, and they told me.
It's not just a matter of knowing the codes. I mean, anybody can look up the codes if they have nothing better to do with their lives.
Right.
But, understanding them and also the interplay between those and all the other areas of law it can get quite complex, and even for attorneys that practice this on a daily basis, it's challenging.
Right.
So
yes.
If you have a friend who knows the answer to questions like this, then they ought to be attorneys, because
So was that movie where she became an attorney by activity? Oh God, I forgot the name of that movie. She didn't go to law school, but she got some kind of.
Was that the Reese Witherspoon movie with?
Yeah, I think it was. Yeah, something like that.
Yeah, I don't remember the name of it either. But it's pretty funny. Yeah.
So, Mark, what's a good way for people to reach you? Because I know everything is so customized. This is such a broad subject.
Yeah, my webpage, the best way to reach me and also to get information on the various bankruptcy chapters and everything else about bankruptcy is simply to go to my webpage, which is at bklaw.com. That's B as in bankruptcy, KLAW.com, and my phone number is 818-509-1173.
Thank you, Mark. Thank you so much.